All right. So this is, it's 3 o'clock. It's, we're meeting, the Legal Advisory Committee of the Redistricting Commission is meeting. And because our general agenda was posted online, but we don't have written copies of that, I will verbally list the agenda items. The first agenda item is training for commission, and that involves training, an update on where we're at with our training on Bagley-King and Public Records Act, where and when and those issues. The second item carried over from the last meeting is the criteria and selection of a voting rights attorney. And the third item is hearing back from Mr. Miller on the issue of Section 8253, which states that commissioners are not permitted to discuss redistricting matters, and we had asked Mr. Miller to look into what a definition of how broader that redistricting matters phrase is and what is encompassed within it. And then fourth item, we had an item on our disclosure policy, also for Mr. Miller to present. We had these are all items that were that the full commission at our last meeting requested we handle at this advisory committee and come back to them with at a full meeting tomorrow. We had a request that we talk about Robert Rules of Order, and that speaks for itself. We can talk about what we want to do in terms of that for the full commission. Third item is whether the advisory committee should have a public comment period the same way we do in full commission meetings. After we finish our agenda, we usually in our full commission meetings, our last item, standing item, is public comment, and we instituted the advisory committees ourselves. They're of our own creation, and so we're trying to work out how what the good protocol for these meetings should be in terms of public comment and other issues. Fourth item that the commission kicked over to us to consider today is how should we and who should prepare some guidelines for public meetings in terms of making sure that all the public participates. How should we make sure that there's adequate time allocation, and that when everybody gets a chance to speak, that people don't extend their time, and maybe proposed rules of order for those public hearings. Our first one's going to be Saturday, so this is probably an item we need to discuss and take back to the commission for decision tomorrow, because we'll be having our first statewide public hearing on Saturday. Then we have I think a fairly complicated issue, maybe not complicated, but interesting issue raised by Commissioner Antai, which is regarding votes on the maps. So if a full commission, all 13 members, has not been present during a formal hearing where we present a trial map, can the commissioners who are not in attendance at that meeting where we get feedback on our trial map vote on that map? We can discuss. I mean, I don't expect for us to resolve that, but that's an issue they want us to begin to consider. And then last, conflicts of interest and application of such for consultants. That's an item that we've had kind of pending for a while now, and that we really need to discuss and make some recommendations to the full body of, well, that's clearly true for staff. We haven't made a decision about consultants. So.
And I wasn't. Are we live now?
Yes.
So I know on the public, publicly noticed agenda, there's an item, and it may have been placed on the agenda by the chair, but I know Ms. Umfleet is here to discuss contracting procedures, and I wasn't sure where that fell within what you had just mentioned, or if Ms. Umfleet has a certain time constraints at this point in terms of when we should put her in the agenda, but it is on the public agenda.
Okay. Sorry about that.
And do you have a rough sense of how much time? Is it more of an open discussion, or is it a presentation that you're?
Because we don't have the same rigorous procedures for the selection of legal counsel that we do for. Yes,
Oh, that's what it is. Okay. I'm sorry. Okay.
No problem.
So that's for the.
Yes, this issue
This is
deals
for the-
just with the Voting Rights Act.
Oh,
counsel,
okay.
which
I
is
see.
fortunately.
Okay. I wasn't clear on that. Okay, that's fine. That helps.
So what we'll do, if it's okay with my fellow commissioners and with you, Mr. Miller, is when we have the item on the voting rights attorney hire, perhaps you can introduce this issue of what we need to do in the presentation, and then we can go into our conversation. Does that make sense?
Yeah, could I make a couple of comments on the agenda?
Sure.
We will be able to address each of the items, and hopefully some of them we can do expeditiously. And the reason I hope that is that it is our goal to get your comments on and be in a position to issue what we're calling the request for information for Voting Rights Act counsel, either after this meeting or after the full commission meeting if you want to bring it back to them. So this one's almost ready to see the light of day, but I want to be sure we have enough time to conclude our discussion so we can issue it.
That's great. And so that'll be our priority item, and perhaps I would say the two priority items need to be that and this item that's been trailing now for a while about the conflict
All right.
of interest.
So if you'd like, we can talk about that one first. This item actually also appeared this morning in the, I have to refer still to the agenda, the Technical Advisory Committee. It came up in connection with the fact that we are retaining consultants there. So in anticipation of that meeting, we prepared a draft policy, which Commissioner Anchetta commented on.
Yeah, and I think we proposed some minor amendments to one of the sentences.
To the other commissioners.
I think we proposed some minor punctuation changes on the last sentence. But I'll highlight them as we go through it.
Would it be most expeditious if you summarize the discussion of the committee this morning, Commissioner Anchetta?
Oh, sure.
See if this will work for us here as well.
I think overall it's simply making sure that the staff and consultants are bound by basically the same policy that was put in place for the executive director, which is, again, fully consistent with what was done in terms of the...
Actually, the policy gives the commission more discretion.
Oh, that's right. I'm sorry. Forgive me. More discretion pursuant to the Voters First Act and the regulations in terms of requiring, disclosure of prior employment, prior consulting work, et cetera, in order to make sure that we're keeping up with the spirit of the act and that we, are clear about our consultants and staff being impartial and not having conflicts of interest. So I think it's what Mr. Miller is proposing is simply the clarifying language to make sure that we are following the act and have the power to do so.
I mean, in simple language, doesn't simply say we're going to apply the same standards, but in order to get approval, we're going to consider that we might potentially waive those standards.
It gives you the discretion to waive it. You require the same level of disclosure, but you might feel, for example, that even though a consultant did work for a party that someone could complain about, you feel they're still the best person, and that in the context of the commission being the client here, that that prior work should not preclude the individual from working for the commission. So you would learn everything about them, but you will have the discretion to make a determination about whether it ought to disqualify them or not.
So it's disclosure of all the same information that was required of commissioners and executive director, but with the ability to waive it if we think that we still have a candidate that can be fair and unbiased.
That's
and
correct.
impartial.
And again, we suggest, I'm not sure if this, I think this probably requires formal adoption by the full commission, but we made some, just some minor punctuation changes. I think there's a little bit of lack of clarity on the last sentence, which if you read it, has 2 points to it. One is that the Act and the regulations authorize this discretion, and that the Commission will apply its provisions with that discretion. And I think what we suggested in that, at least in the technical committee, was simply adding another comma after. Yeah, so it's sort of authorized comma, and the Commission will apply its conflict provisions with discretion, comma, while also assuring the impartiality of staff and consultants. Delete one of the periods at the end of the sentence. So.
And I'm just curious what the discussion, in order to sort of jumpstart our discussion, what was the thinking of that advisory committee, that this, is it the sense that if we didn't have the discretion that we would really be limiting our pool, that this becomes very...
I think it was to give us the option if we needed to exercise. I think, again, ideally we have a pool that where we wouldn't have to necessarily waive these things. But if we needed to, because we felt that the best candidate was available and that this was an issue, we could, in fact, waive it.
I mean, the reason I ask is it's one thing to say, and this may be really splitting hairs, it's one thing to say it's disclosure, that it's basically a disclosure requirement with the ability to waive. And it's another thing to say there's a presumption that the conflict means that we can't hire them, and then we can waive. It's a little bit different. If it were really like the commission and the executive director, it would really be stronger than just disclosure.
Yes, but went back and talked to the people who prepared the regulations that implemented the statutory provisions. And they advised me in their memos that were prepared along the way, this is the Department of Audits, reflect that their intention in drawing the very strict regulations was with respect to commissioners. And the statute itself gives the commission some level of discretion. So we're simply trying to clarify for the commission what we believe the state of the law actually is here, which is that the very high level of presumption, if you will, applies to the commission. It doesn't apply to the staff in the same way, but we think that you ought to have a lot of information about anybody that's working for the commission, that information might very well cause you not to hire somebody, but not to box you in on a technical piece of work or appointment that somebody had along the way.
So would this eliminate the issue I think we've come across a couple of times, I'm not sure how many, where we ask people to do a conflict waiver?
Well, you could decide what you want as it relates to the work we're looking for right now for voting rights tax lawyers. Just tell us what you want them to say. You know, we could, for example, attach the same, we would provide them with the conflicts provisions commissioners have and say, you know, this doesn't necessarily conflict you out, but tell us, have you done any of the work that is described in this conflict? And then you'd have it in front of you, and you could make the determination.
I think I understand. Are any
No, I understand that.
other comments?
No.
No, and there was very minimal discussion at the technical committee.
Okay. What I'm going to do very quickly then, is go to the voting rights attorney discussion, and then seeing as that's going to be fairly long and there may be some public comment about this first item, after the discussion and whatever recommendations we arrive upon, then we can have public comment after that.
Sure.
These first two items.
Let me just introduce the VRA discussion if I can. And while Carol's here, she may not have to spend quite as much time with us. The California contracting law does provide a simpler method for us to contract with lawyers than with other providers. So we're, if you will, the beneficiaries of that exemption, which makes our contracting process simpler. What I've tried to do in the document that you have, and do you have this in front of you? I emailed it to you, but if you need a copy, I have additional copies, was to set out a relatively straightforward solicitation to get complete information about the work the firm has done and how they would go about this work, and a discussion of how they would bill for the work. I think that's an area we need to return to and discuss further, even as it's stated in this proposal. So in a perfect world, this will go out, let's say, well, whenever we're finished here, and if you want the full commission to approve it. We'll be ready to launch this one. It contemplates that we would have, and this is all subject to discussion here, of course, the statements of qualifications back by March 14th, and that we would be in a position to make a determination about Voting Rights Council at our next committee meeting. Now, exactly the form of how that would work is a subject for this committee to discuss. There's a range of possibilities. You could see,
Just one thing. Do you want us to go through the whole thing and then go back, like on the timelines and all of that, or
I thought
whatever you?
I thought I'd just take a second to sketch it out.
Yep. No, that's great.
You know,
Okay.
start with the big picture in this case, and then come back and resolve these things.
Okay.
So the goal is to finish and have somebody in place by our next meeting. That's our goal. You need to determine how you want to be involved in that process. It could range from our staff sorting them out depending on how many responses we get and bringing you a subset of those. Depending on how many we get, you might want to review all of them. We may make a provision for lawyers to come in and present. Again, that could be all or a subset. So, not sure where you want to come out at the end game, but between now and the next meeting, those are the kind of the range of possibilities. But with that in mind, then I think it makes sense to return to the document and get your specific comments on it.
And when you say we, you mean this committee or the full that?
Well, for the moment, I'm referring to this committee.
Okay.
I'm guessing, but you know, it's up to you that you'll want to take to the full commission, the selection of the VRA and exactly how you wish to do that, something for us to decide today.
Okay. It's just, I know there's discussion, and tomorrow we'll have a better idea of our schedule. I think there's our director is recommending that we not meet when we're scheduled to meet.
Yeah, we're putting the next meeting off another week. I believe it will be in the March meeting, and this is keyed to that date, would be the 17th, 18th, and 19th.
So those are the dates we're looking at for this committee to potentially have a recommendation, to do it at that meeting.
That's correct.
All right. Okay. Okay, thank you. Okay. So I guess my question, just on the timeline, is whether that's realistic or very, I mean, we know we need this yesterday, but given that people will send in their statement of qualifications by the 15th of March, which is
Is that a Monday? What is that?
That's a Tuesday.
Tuesday?
Tuesday, which is what from today, like a little less than 3 weeks from today?
Yes.
So we have we go tomorrow, let's say we get approval on this, they would have a little under 3 weeks. We would have 3 weeks to basically make sure we had very good outreach and that we had good notice, good posting, and we had good candidates in 3 weeks. And that we'd done whatever we might want to do in terms of, as you described, the range of input that people might want to have into that process. It would all have to be done in the next 3 weeks, correct?
That is correct.
So what's your sense of that?
Well, it will be our top priority. It will be, I think it's doable. I'm anticipating that a law firm can look at this and in roughly a week's time make a determination we're interested. They know the work they've done. You know, it's going to be some hours of work for them certainly to put this together, but I think we're giving them I guess I'd say we're giving them just enough time to put together a proposal. It does not give us very much time to review them, but it's not like going through accounting records. I think
That was more my concern, is that not so much that they didn't have enough time, but that we didn't have enough time. I would be more comfortable if they came in on a Friday.
and we can make that change. And then the question too becomes how much time the committee wants to spend as a committee going through the materials. It's contemplated, and I think it probably has to be a public meeting, so it's not as easy to do it in that setting, but it certainly, again, can be done. You'd be provided with the same packages I receive, of course, and it'd be a good discussion.
Would it make any sense to, and would it be allowed, I'm on you, that, and again, I have no idea how many of these we'd get, but whether it would make sense for us, the four of us, Jody not being here, to vet the ones that we get and submit some number of qualified ones to the full commission, so they don't have to look at all of them?
Actually, I was anticipating that that's how it would work, that
Okay.
the committee itself would take that responsibility of working through the responses and make a recommendation to the full committee, so that the work would be done at this level.
Okay.
Now, I wasn't clear from the language of the RFI, would staff be doing some initial screening here, or will the legal advisory committee sort of being involved in the first cut?
This wasn't really intended to say one way or another. I wanted to come back to get your guidance about how you wanted to proceed.
I guess I'm a little concerned about the timeline. And, I mean, one of your points sort of was one of my questions, which is the solicitation, for lack of a better phrase, the solicitation of law firms for this position. And so we hadn't really, I mean, it's come up sort of tangentially, but we haven't really said, we had always talked about an attorney. I don't think we'd ever said, oh, we're going to solicit a law firm to do this work potentially for us. And in fact, I think there were some concerns expressed at some point about
We want to try to avoid
law firms.
contract, per hour basis because we'd lose control of the costs.
Well, I did try to set this up so that we were aiming it toward both lawyers as individuals and law firms. I'm assuming, let's just take the case of someone who's with a large firm, who's the specialty person at that firm. You tend to get the firm with the lawyer as opposed to the lawyer on his or her own. But I was trying to write it in a way that would permit an individual practitioner, an academic, or someone else, as we discussed, to respond, to be able to respond and in no way be disqualified or disadvantaged because they're not with a firm.
Correct. And so my concern is more with the firm. So here are a couple of thoughts. These are sort of different thoughts, but so if we say firm and then we get, you're not going to find a lot of firms. Some firms may have a side practice in this. That's possible. Or there may be one or two that do this as this is the bulk of their business. The reality is that most of those are on the defense side. So if we were to say firm, would we also say organization? Because there are organizations that have a voting rights practice, and those tend to be on the plaintiff's side. So I'm trying to really be, I'm trying to make this as impartial from the very beginning as possible in the way that we even word who the potential applicants are.
I think that if you're more comfortable, we could drop the term law firm and just refer to lawyers. I don't think it'll ultimately make a difference in the response. I mean, let me just throw out a hypothetical. Let's say Warren Christopher wanted to do this work. I think that's highly unlikely, so I'm using his name. If he were to want to do that and we said you're the right guy, you'd get O'Melveny with it, undoubtedly. And that's why I throw in the law firm. But if the committee's more comfortable just talking about lawyers, I think that works just as well for this purpose.
I just raise it because I think there will be a perception that law firms versus there may be nonprofits who do this work, and are we favoring one sector?
Using the term law firm does cut out people who participate in this practice.
Right.
Would you like to just use the generic term attorney?
Yeah.
And we'll delete the law firm reference?
Yeah, and you could just do attorney with sort of parentheses S to include the plural. I don't feel as uncomfortable because I think it covers a lot of ground, but I think the point is well taken that there are entities or organizations that aren't necessarily within the phrase attorney or firm that we want to maybe get some applications from that sector too. So I think the broadest language possible would be fine with me.
I would feel better. Like, I'm just thinking there's this, the Brennan Center that has a big part of they're a nonprofit. And in fact, one of their former staff persons did a training for us, and what if they decided to do something? So they wouldn't be a law firm necessarily, so. So I would be more comfortable.
What if we did this? Under Section 2, that first sentence says that seeking statements of qualifications from attorneys and law firms. What if we said attorneys and then kind of define that paren, including law firms, not-for-profit entities, or other entities providing legal services, something like that?
That would be great.
Not limited to.
Yeah, that's great. And that the reason I had raised it to begin with is I think a law firm can marshal this kind of SOQ very quickly, and an individual attorney may have a harder time putting this together in a short, and which is one of the thoughts I had is, does this favor people who can put a package like this together very fast, this timeline?
Remember that the timeline we are proposing here it just reflects the urgency that we felt from the Commission, but it's subject of your discretion in this meeting.
Again, I'm concerned that we're not going to have enough time to review them. I'd personally move it up to 10. I'd put
You leave the final date the same, but move the solicitation.
Exactly. Give us more time to go over it. I mean, I recognize it, but if they want the job, and I think people, we've talked about, people in the industry, so to speak, know about this. I mean, this won't be something, it just appeared.
We're talking nationally. We wanted to have a national reach. And, I mean, for example, some of the calls you made already, you see how hard people are. The higher you sort of go up, in terms of the food chain on these matters, the people we're looking for maybe are very big. I'm a little nervous that
let's give them the weekend. If they want to work the weekend, that's their business.
Yeah.
So let's make it the 13th.
Okay.
Commissioner, how do you feel about just moving it up a day, or should we just?
Well, the 13th is a Sunday, right? So I would just, I'm okay with the 14th.
You said it would be a Monday. You said Tuesday was the 14th.
I don't have my calendar.
I
have the 13th. I have March 13th as a Sunday.
I've got it as a Monday on.
Wow.
This is one, however, that can be conclusively decided.
I'm looking at the official calendar of the commission. So, assuming Google Docs is accurate.
Okay.
I've got it. Yeah.
It should be due that
The
Monday.
14th is a Monday.
Yeah.
But then the 14th stands in. Okay.
I'm sorry. Yes, the 14th.
Then the 14th
Okay.
stands.
It was.
All right.
It already was the Monday that we.
Okay.
All
So
right.
we'll leave it on Monday.
Monday, yeah.
Okay. And then what about the turnaround time for us to the consideration by both this committee and then the full commission with a public hearing? Because we're also talking about.
Right.
So what is the calendaring, the proposed calendaring of the meeting? Would it be the advisory committee's meeting on the Wednesday, the 16th, or Thursday, the 17th?
I believe that the advisory committee meeting has been moved to the 17th.
17th. And then the full commission on 18th and 19th.
That's correct.
So we would want to look at it prior to the advisory committee meeting, and then sort of.
They need to get the stuff, and then we need to get the stuff
Right.
over those 2 days. That's a Tuesday, Wednesday.
Now will we, so in other words, would we at that point be discussed, let's say we have a ranking system, and then we will say, we will, during our advisory committee meeting, discuss the top 3 candidates,
Or determine who they are.
right,
'Cause we want
at the
to-
meeting, at that meeting,
At the advisory committee meeting.
and then have closure
And
and
then,
a decision.
and then we can recommend
Recommendations to the full
to
commission.
the full commission, and maybe we'll recommend 2 or 3. But we'll.
I just want to add, to follow on one more step, one thing you might do, let's just say we get 10 responses. You might reduce that to 4, invite those 4 lawyers to come speak to you, tell everybody they're on call, and because, we could get a very fine presentation from someone who's not known to us, and you've had the experience of an excellent resume does not match the personality of the provider, and we don't want to be in that situation where we end up with a difficult person who's great on paper. So I think there ought to be some kind of face-to-face encounter.
I completely agree, yeah.
As I joined the commission later, and with other staff hires, was the full commission involved in the
Yes.
interviewing process?
Yes.
Okay.
What we did, like for the executive director, we had a list, and we called the pool down to like 4. Did we down to 4? And then we interviewed the 4. And we did the same for our legal counsel. I think we had 8,
Okay.
and we called it to 4.
So I guess it's feasible to have a closed this is done in closed session, right?
So I don't believe it can be done in closed session.
It's the interviewing, or the presentations, or?
I don't think so.
Oh,
I wanna look
this
at-
is a bid, this is more of a contract.
Well, it's just that.
Yeah, it's not
than
personnel.
a personnel.
Yeah, that's right. It's just that Bagley Keene
Okay.
has not presented an exception I found to permit us to do it in closed.
Well, and that's fine.
So then we get everything on the 14th, and then our advisory committee is the 17th?
Correct.
Right.
So we have the 14th and the 15th and the 16th.
Realistically,
We have the 15th and 16th to sort of do a cut.
Right.
But that means includes an interview.
You really, you've got the 17th to do the cut, in a sense, because it's
That's
a
true.
public meeting.
That's right. That's right. So we have the 15th and 16th. Now, can the interviews also have to be public?
Yes.
Right. So one question is, are we as a committee doing presentations and interviews, making a cut, and then whoever's left, does that go in front of the full commission?
I think we should make a cut, and then you can't ask people to make presentations twice. I don't think, not sort of consecutive days. I think we should make a cut and then ask the ones who make it to make a presentation. Again, that's what we did when we hired
Okay.
the various positions. We just made a paper cut, and then we ranked them and took the top 4 typically to be interviewed, actually make a presentation.
By the full commission.
Right.
Okay. So if we were to do that, would we allocate some time on Friday the 18th to have the top 3, the top candidates
We'd have
come in, make a presentation, and then the commission would ideally make a decision at that point?
Right, because
Yeah.
we have to make it by the 19th.
Just one more factor, and I'm afraid it's an unknown. We were hopeful that at the next meeting, we'd also be able to choose the line drawing consultant. If that's the case, that might be on the Friday. I'm hopeful that we can still meet that schedule, but as you know, Commissioner Anchetta, that we have challenges in getting that done in this time as well.
Sure.
Now, I know that for the personnel hires, we were able to, our director did make a first cut and then presented. Would you be able to do, under the Bagley Keene, do a first cut?
I can. That's the kind of guidance that
Okay.
I'm seeking from you.
Okay, so I would say that's, especially if we gave you some guidance as to what the first cut consisted of, the criteria, that we don't necessarily have to see them all, or, I'm open to this. What do folks think? Do we want to see them all, or do we want to have our council make a...
Yeah, I'm agnostic actually on the specifics, but this did come up in the technical committee regarding the line drawing consultant, and I think there was generally, and I don't think it was fully resolved either, but there's going to be some research in terms of what the process is and what the state contracting manual requires and doesn't require. But I think there's been a push, both among public commentators and at least the technical committee members, to have it as open as possible, sort of the push. I personally don't have a problem with staff screening, but I understand that there's a sense that as much of this should be open as possible. There may not be as much concern around the VRA attorney, I'm not sure, but certainly around the technical consultant, there's quite a bit of concern that as much as possible be open to the public.
Well, I think
see.
I think the potential for controversy or interest in who the VRA attorney would be. would be something that, this is not like hiring a public information officer. I mean, there's
One
more,
other
there's
thing
more
to
stuff.
that, it's difficult to compare one good lawyer who makes a good presentation and an entity that does the same thing in terms of the judgment about who is the commission going to want to have. So I think there are good reasons for the full committee to be involved in this.
Yeah, I would want to see.
I agree. I agree. So then the way it would look is, but we would in subcommittee, or we're not calling them subcommittees, an advisory committee, we would make a recommendation?
I think so. I think that's the only way we get this done.
we-
I think that.
So we look at all of them, we make a recommendation, but then, and that's public.
Okay.
Yes.
Because these are public meetings. So the public portion of this gets handled through the advisory committee meeting, in a sense, that where people see all the all the candidates, and then when we go to the full commission, and we make that very clear.
Yeah, and we can limit, under Bagley-Keene, we can limit the public comments just to the committee, and then, so that it's basically taken care of, the public end of it is taken care of at committee.
Right.
And then
we go forward to the full commission with our, whatever,
We're gonna recommend
1, 2, I don't know,
How
we,
figured.
Yeah, I would.
Okay.
Yeah, I would just say it's the best result would be if the committee were either to say, we want one lawyer and this is our first choice, and present that choice to the committee or to the commission, or we've decided we'd like to have two, and these are the two.
Okay.
Now, I think the thing to do is, we've got a long time to report out tomorrow morning to the full commission. So we can have that discussion with them, but just might be easier if you were comfortable with a recommendation to lead with that recommendation tomorrow to the commission.
I am. I think that we have a very involved and opinionated commission, and if they don't like our recommendation, that's, they will let us know. But I think, given the time frame and the fact that we will have to be interviewing and and then having the person in place, I think it makes sense actually to go forward with if not, you're really going forward and saying, now reopen, then you're reopening the whole conversation
Right.
again.
And they haven't been privy
and
to
they haven't,
the previous
so,
conversation.
yeah.
Having just forcefully advanced that position, it does occur to me, the one thing that we miss, though, is that opportunity for...
To interview.
To interview.
Do you hear the president?
Yeah, if we present one, would we but would the commission then also just interview one person, and that's sort of
You're
a
going
false...
to be hearing from that person for the first time.
I wonder whether we should, again, go back to paper screening so that the subcommittee gets the presentation. And the recommended candidate, if there's one, makes it again to the whole commission. So they get to see the person that the subcommittee is recommending. So at least we hear from several candidates.
Right.
Right, and our meetings are open, so, other commissioners
Yeah,
can come, and I'm sure there'll be a lot of interest, and they can come and, participate. So let me see if I've got this right, so, for tomorrow. So, this committee will actually do the first cut, and we will recommend one candidate, or if we decide to go with two attorneys rather than one, we recommend the combination of the two, to the full commission. And the advisory committee meeting is where we will have a full discussion. And where, the only thing I'm missing here is, where do we interview and have the presentations by the candidates? At the advisory committee?
Right. And in fact, I think one step was left out. Let's say there's 10 applicants. I think we will read the material.
Yeah.
Right.
But we'll ask staff to recommend 4 for the subcommittee to come stand in front of the subcommittee and make their pitch. Then we will recommend from among those who made the pitch. Now, we can influence who gets to make the pitch, because we will have the paper stuff if we just think this person should not have been missed. Because we can't have 10 people make presentations.
Right.
And we don't want to have 4 made to the commission.
So purposes of complying with Bagley-Keene, how do we do that? If we delegate to staff, that's not a problem. But if we're making if the advisory committee is making some decisions, can we do that in compliance with Bagley-Keene absent a meeting?
No.
No.
We're not absent a meeting. How are we absent a meeting?
Well, we would meet to get the top 4, let's say. Unless we're delegating to staff, which again, there's no problem with Bagley-Keene at that point. But if we are, the members of the committee are also involved in the screening, and we're going to come to some agreement that there's a top 4. In order to reach that agreement, we have to talk to each other.
That's a decision.
That's a decision. So that, in and of itself, is a meeting.
I see what you're saying.
Now, I have no problem if we want to calendar a meeting,
Yeah, I was just thinking, we have time, if you wanted to do it, we could meet, say, the afternoon of the 16th.
Yeah.
Perhaps, well, let's see, I guess you do the paper review then, and then invite some number back on the 17th, just tell people they're on call.
If these are national candidates, that's not going to happen.
That won't work either.
We need to meet Monday. So at least they have a couple of days to get here, if they're inclined to get here, it seems to me.
I see that Jody has marked, Commissioner Filkins-Weber has marked off several of those days as unavailable. I don't know if that's still...
Is she available the 14th?
It says unavailable.
What about 15th?
14th, 15th, 16th, 18th. She's listed as unavailable, but...
That's that whole week.
Yeah.
Wow.
Yeah, in fact, I did speak with her about the 17th, and she can get here by about 3 o'clock. So we're thinking of an afternoon meeting, even at that.
What does her schedule look like the next week? I can't get online
She's
here.
got 3 days out, so it's 21st, 22nd, 23rd.
She's available.
Unavailable.
Unavailable.
She opens up again on the 24th and 25th.
Could we forward her information and she can
She can review, I guess.
review and make...
Again, it's a question of the meeting. I mean, if I don't know how unavailable she is. There's always that off-site public meeting option, which is to have it available to the public as well. I don't know what degree she's truly unavailable.
You're correct about that. I don't, from a legal perspective, I think it'll work. My sense is it won't work for her calendar.
Yeah, and because she's out, she's out. That's it.
So will it work for her? I don't see a problem, but I don't know this well. Sending her everything we get, all the materials we're going to get. Let's say we get 10 candidates, and we send them to her, and she can communicate with you about her opinions, her concerns, her questions,
Yes.
her reactions. She could even help formulate some questions for the presentations. I mean, is that? I mean, I just go baback to being concerned about if we're going to, like DOJ folks out of Washington, D.C. I'm sorry. Thanks. I was too comfortable. Yeah.
If we have people like DOJ folks coming out of Washington, how can they get here? They can't. I mean, they have to have a couple days' notice. It seems to me they just can't.
Right. I was just trying to clear up the issue of can we get maximum participation by Commissioner
Right.
Filkins-Weber short of her presence. And I think we could try and maximize it because the only other alternative is to try and work around that schedule.
She would have to look at the stuff Monday night, it seems to me. So on Tuesday morning,
We get people out here.
right, we can at least alert them. You need to be here Thursday if you're really interested.
The thing is, what I can't communicate with you
Right.
what she communicates
That's right.
to me, except in the open meeting.
Right.
That's fine.
Okay.
That would be fine.
As long as
That's
we're
fine.
complying with Bagley-Keene, if that information comes out in the public meeting.
Yeah. That's
And
fine.
she agrees to that.
Well,
She
process-
agrees that to know, I mean, she
process.
would be doing it publicly anyway.
I don't think that really addresses Commissioner Forbes' concern about giving people enough.
You see,
Right, that's a different issue.
I think what we're going to have to do is we're going to have to delegate to staff to make an initial cut. I don't see how we can all get together and talk about it in time to give them a chance to get here if they're coming from out of state. I just
That's,
don't-
is that without, so that's a paper cut,
paper cut.
and no interviewing at all?
No. A paper cut for the first reduction,
Okay.
and then staff is going to recommend that we hear these four presentations on Thursday, and staff on Tuesday morning can call the four
Okay.
and say, if you want to come, let me know. And staff could rank orders, because if one of them says, I don't want to come, I can't come, then you can go to number 5. So we have 4 people in front of us on Thursday.
Okay, I guess one thing that would make me feel more comfortable is if we had the option to draw somebody out of the pool that you might have cut. So we get them all, and you make the cut, and if it's that person that we were very interested in is not in the cut, we let you know.
The thing is,
I mean, I know I've done that in other searches and hires.
I'm not offended by the process at all. What concerns me is that you wouldn't be, except on an individual commissioner basis, which might be fine, we wouldn't be able to have that discussion except on the 17th as a
Right.
committee.
I mean, we would have to decide that if there's somebody on this list that didn't make the cut of 4, and you want to interview, you call Kirk, and he says, okay, this person's in.
Then
There's no discussion, you're just in. We just have the ability to include anybody we want to out of the pool, which is okay, but I mean, that would have to be how it would have to work, I think.
And we would just have to have a degree of trust that we're going to use that option very
Yeah.
cautiously, that we're not going to just be undercutting, the authority.
I don't have 10 people show
Yeah,
up.
show up because all of us decided we
Yeah,
wanted to see
exactly.
this person and that person. I don't know. I have to say, I'm torn because this is such an important decision. And as we've all said, I think for the public, it's a very important decision. And for people to feel that if they come to a meeting and they hear that there were 12 candidates and that they're only going to be able to see and hear from 4, it's like, well, what happened here? It's just that kind of, I think this is, like you said, like as with whoever we hire for consulting on the lines, this is sort of that magnitude, this decision.
Yeah, this sends a signal for those who are watching.
Well,
Okay, go ahead.
My feeling is, I think we want to be as transparent as possible and allow as much public comment as possible, but I don't have a problem with somebody, I think it's still the advisory committee commissioners, but making a cut that the public will see, okay, well, they had to make a cut, because there's a lot of candidates, it could be 20 candidates, 30 candidates. I don't think the public necessarily wants to see all of those candidates. I don't think. But
Tell you what,
it can certainly be publicly available. We can make these publicly available on the website.
I was going to ask,
there can be
a
comments.
statement of qualifications be posted, people's SOQs be posted? Is there a privacy issue with that?
I've said in the solicitation that this is not a confidential document and that it will be available to the
I
public.
mean, I think that's useful, but I'm thinking, again, I'm going back to, that didn't help us cut the list. I wonder whether, there's 2 cuts here going to go on. There's going to be the initial cut, and there's going to be the final recommendation.
Right.
We may not be able to accommodate Jody for the initial cut.
Right.
We just may not make that work. So it may be up to the 3 of us. She can make communication with Kirk as much as she wants,
right.
But it's up to us to cut the interview list down to 3 or 4, however
Right.
many.
Right.
She will be here to make the actual recommendation. Because she'll be here Thursday. We'll have a meeting here. We'll get the 4 presentations or whatever many there are. And she will be here for that.
Oh, that's interesting.
And so,
Although, just caution, it looks like 3 o'clock is as early as you can get here if everything
and
goes well.
we're here 3 to 9 then, or 3 to 10. I mean, that just,
No, that's not a-
that's not a problem. But that's would be a way so that she's at least involved in the final recommendation.
And then we asked, as we're moving along, we'll have enough time to let folks know when they have to be here.
How do we do that?
Okay, that's what I'm trying to count now. So deadline's the 14th. Under this system, we have a first cut by you.
No.
No?
No.
No, we
First cut
have
by
a,
us on Tuesday.
on Tuesday.
Okay, so we'll schedule another meeting.
We schedule a
the
meeting
three
on,
of us.
okay,
The
so,
four of us Not paying
okay,
attention whatsoever to your schedules.
okay. We make our first cut on the 15th
Preferably the morning.
with, the candidates are here.
No.
When do we see the candidates?
Okay.
On the 7th.
On the
Okay, all right,
17th.
so our first
we-
cut's
we
a paper
get
cut,
10,
a paper
and on-
cut.
And on Tuesday, we cut out 6.
And we can
Okay.
publicize in this initial document, the 17th is the
Right.
date we will,
That's-
anyone
Yeah.
selected
Yes,
for
right.
screening.
Please
Yeah.
be available.
Right.
To get here for an interview.
That
Okay.
gives us some notice of
That's
it.
That's
right.
good.
So then the next step is that, and that's very public, so everybody sees our first
Right.
cut. So we have to notice that meeting. And then we interview,
The 4 of us now.
yeah.
Who's now here.
Full advisory committee. Interviews on 18th.
17th.
17th? On March 17th, from 3 to 10 or whatever.
Right.
Whatever.
Whatever.
17th, 3 to 10.
And we make a recommendation. Out of that meeting comes a recommendation of 1 or 2, depending on what we choose
Right.
to do, to the whole commission.
And then we're meeting the 18th, so we
Yeah.
are able to do that.
Right. And we can ask, because the person who's been here to make the presentation on the evening or the late afternoon of Thursday, or the 17th,
17th, right.
to be available
Stay over.
to stay overnight,
Yeah.
so they can make the same presentation or a similar presentation to
Right.
the whole commission, and they can see what we saw.
All right, do you want to go through that?
Yes.
think I got
What
it.
I would propose to do then is to add language to this solicitation that advises the candidates that those deemed most qualified by the commission will be invited to present the afternoon of the 17th, and that we anticipate a determination will be made, and that one or more candidates may be requested to present to the full commission on the 18th.
Do we pay their way?
No. Well, I'm sorry.
I don't know.
I mean, this is one of those things where you sort of get into equities if there are people who are, I don't know. I mean, you think if people are interested, they'll come, and that's that?
Well, I mean, I'm not going to pay their airfare. I mean, that's way too much money. I mean, that, on short
On
notice.
short notice?
You know, having been a private practitioner for a long time, we did not have that experience where there was a fee associated or compensation in making a presentation to do work.
Having been in the nonprofit sector
Different.
for 30 years.
No, I'm inclined simply to what is customary for the state of California to follow.
Yeah.
It's fine with me.
Yeah.
I understand there's
Whatever the
different,
state-
but I understand in different sectors there's
Yeah.
quite different
Yeah,
customs.
So we should go with
So-
whatever the state does.
It's a fair question. You know, with our rules, I'd be glad to investigate whether we can, in fact, reimburse people
Right.
for doing that.
We're doing that, and we let people know, and then we amend also to say that under state rules, blah, blah, blah,
Right.
so that they know
They know
that that's
We're
why.
not being arbitrary.
Right. Okay, so I had a couple of substantive, as if these weren't, on the qualifications themselves?
Yes.
On the document?
Would this be in section?
So this is, it's where we talk about what we expect them to be familiar with. What section is that? Experience?
Statement of work and experience,
Let's see.
section 5.
It's personnel, blah, blah, blah. Okay, section 5, number 3?
Advise.
Advise.
Okay.
And with respect to, quote, racial gerrymandering, unquote, I don't know if I would use that phrase.
Yeah, I would like to, is that a term of art? Is there substance behind that phrase? Or is that just
Well,
a phrase?
it refers to the sort of a line of cases involving equal protection claims where race is either very, very odd-looking districts or race is the predominant factor.
My only concern, and maybe this is where you were coming from, the term gerrymander is a very negative term.
That is what I'm saying. I mean, I think that may be the language in some of those cases which were 5-4 cases. That does have, it's a little loaded. I mean, I think, I don't have a problem with, and in fact, I think we should really have people discuss their experience with doing, analyzing racially, either in part racial districts or, but I don't know that was the phrase sort of, I thought, I don't know. But if you think it's a term of art that's just, I would prefer to say the line of cases, the Shaw versus, blah, blah, blah.
Yeah, you could say the Shaw, if you want to get that specific. I was actually going to suggest maybe just...
Or sort of more general.
Yeah, you can just say federal constitutional claims as a general term, but you could also say the Shaw versus Miller Shaw versus Reno and Miller versus Johnson
Right.
line of cases.
That would,
Yeah.
If you want to get more specific.
Is that what this is?
Yeah.
I mean, anybody applying for this job better know those cases.
Right.
Yeah, if they don't know what that means, then,
They're not going to make the
Probably
cut.
useful for us to know what they are.
yeah. Yeah.
Well, that's why we're trying to get a training as well
Yeah.
Right,
for this
right.
too.
So that was one.
Okay, so we would delete racial gerrymandering and just plug in those case names in lieu of that?
The lines, it's just Shaw versus Reno and Miller v. Johnson line of cases.
Okay.
And they'll know what that
They'll know.
that we're talking about.
And then on conflict, we have here disclose financial.
That's section 6.
Yes, I'm sorry. The second to the last, the two last paragraphs. Please
Right.
disclose any financial, business, professional, or other relationship with the firm. And I think we should say we're not going to use firm, so we have to change firm throughout the document. Obviously, you may have had since it's not a firm. Now, one thing we had in the conflicts, the regs, was lobbying.
Well, we've picked that up in a kind of a shorthand way.
But it was actually very explicit. It's
The regs are more detailed
registered
by
lobbyist within a certain, and I think if we're going to say that we're tracking, that we get to waive it, but we're tracking, then we should track.
I'll add a reference to the appropriate regulation in addition to the government code.
Also, I mean, I have trouble with the sentence itself. I mean, a relation with a firm has any person or entity that is adverse, i.e. opposed, so I read the word adverse, to the CRC or to the state of California. I mean, is this someone who doesn't like the state? I mean, that's what it sounds like. I mean, that could be pretty broad.
Adverse generally means adverse in a case where they're litigating against
Right, no, I
the state.
understand what you're saying,
Okay.
but I don't.
I forget you have this rich background.
I mean, I just don't know that adverse is.
Okay.
I mean, adverse. Those are the guys who voted against Prop 11.
How about this? How about this adverse in a proceeding?
Okay.
Yeah. And then add the lobbying language. And is that, okay. All right. Any other comments on the qualifications themselves or on the fee arrangement?
Oh,
You want to talk, we need to talk about the fee arrangement.
I have
Yeah.
some concerns
Yeah, I
about
do, yeah.
what
We
I've
need to talk
said
about
in this section.
Yeah, we need to talk about the fee arrangement.
You know, in our last meeting, the committee expressed its desire to see a proposal for a fixed fee. But my concern is that we don't really have enough specifics to tell the firm to permit them to do that, particularly around the issue of attending line drawing meetings. I'm not sure that we've fixed either the number of meetings that will be held or the number where we'll want them present. And that could be a substantial amount of work that's just doesn't permit someone to offer a package deal against in its present form.
Yeah. And even the flat fee, it's like, what should we give them more information about what's expected? I mean, it's in here, what they will be doing. Is it unfair to ask for a package for a price, given what we've listed that they have to do?
Well, can we, I mean, it does tend to make them want to lowball a number, but to say, based upon the description and discussions about what we are saying that this time we think we want, and given the hourly rate you'd like to propose, what's your estimate of what this is going to cost us? Because if it comes into some crazy number, then we have to redefine the work product.
Yeah, and if everybody's comes in.
And high, yeah, exactly. Then we.
If I could turn to Carol for a question on this. I think that the custom in legal contracts is to, or one approach that the state accepts is a not to exceed number. Do you understand? My recollection is that's the typical way these are prepared. Do you?
But even now, we have. I mean, how do we make a rational judgment as to what that not to exceed number can possibly be?
It's.
I mean,
I think you're right. On the one hand, I think we've gone as far as we can. Maybe you can help me more in describing the work, but it's still pretty tough to budget against based on this description.
Yep, I think so.
do you think that you can discuss with Dan? I mean, we have this pot of money. I mean, maybe it's $3.5 million. We'll say we'll get the $1 million augmentation. And you've got other items that are being sliced out to pay for things. We have this much money left. We can come to a not to exceed number of some proportion of that, just because that's all we have. I mean, is that something that makes any sense?
Well, we've put in a number in that budget of, I think, $150,000. It's not a number I'm comfortable with.
That makes me nervous.
Oh, I think that's
too low.
Now, it doesn't include litigation, of course. That's
Right.
just the advice number, but you still feel that's too low?
Struck at a gut level without any basis for having that, it just doesn't sound like a very high number.
It's, let's see, they'll start April.
April, May, June, July.
It's 6 months' work, right?
No, April, it's 5.
5 months.
15th of March to 15th of August is 5.
Money it goes very quickly.
Exactly, right. I mean, $150,000 probably I'm going to say $500 an hour. And
Unless you're hiring a staff attorney.
Right, and they don't
That's
get
the virtue.
they don't get the per diems and all that. I mean, the expense, they get the expenses.
What we would say is they could bill at the stated per diem rate for travel.
And for meals and
That's right.
travel. So the package would be a salary, potentially, not to exceed whatever, plus all the state travel budget.
Yes.
So are we prohibit, or does this lock out the option of hiring a staff attorney?
No.
Okay.
I think that staff attorney was contemplated potentially, but I don't think, we just didn't want to lock out.
Right, and that's fine,
Yeah.
as long as we're not locking out the staff attorney
Right.
option.
No, I mean, there's no question if we could find
that's
the
probably
right
the
person.
cheapest way
one
to
could-
do it.
I mean, at the meeting, our last meeting, I made the suggestion that one reason to go to the DOJ is to find some person who would like to leave DOJ, land here for the experience in the resume item, and then after he's done here, or she's done here, go off and,
Right.
into private practice.
So can we, again, we may want to weigh these as options, but can we put that option sort of into the fee arrangement so that one option is for the person to be hired as a full-time staff attorney?
For let's say 6 months, because they'll be the post,
Right.
whatever.
If that's an option, I'd like to
Yeah,
put it
I
in there.
agree.
And then you're looking at, well, what would be a salary, and then do 6 months.
Yeah, and we've got something, we've got comparable numbers for also Kirk's position,
Exactly.
and there's a halftime position also that we're contemplating.
That would fix our cost.
Right, we fix our costs, then we have to do benefits, which,
Yeah, but
I mean,
it's fixed.
it's
We'll
fixed.
have a
It's
number
fixed.
of this.
Yeah, I mean, these open-ended hourly rates is very scary when you have a limited amount of money. You could build half the bridge, you can't finish the bridge.
I mean, yeah, I'm glad you mentioned that. I mean, even somebody who's in the private sector and well compensated, if they come to do this, they're coming to do it knowing they're losing a lot of paying business, and that they're doing it for another reason. Nobody's really going to do this job because it's going to be highly compensated. Now, you can't make it so unattractive that they won't do it, but I think we know that people will do it because it's exciting, it's interesting, it's resume building, it's, it's probably their passion to do this, but we just can't lowball them too much.
I do think you want a senior lawyer
I do too.
who has had the experience of standing up to line drawers, public comments, large commission, potentially the media.
I agree, and
There's
this-
a lot at issue.
yeah, but this is where you're going to get a very small pool of all of that.
And
But if we did, we'd have somebody very good that we should compensate well, you're right.
the other thing is, these dollars, and I'm certainly sensitive to go up very quickly. At the same time, we're looking at the biggest redistricting project in the history of the world, in the 8th largest economy, and in a fabulously public forum that warrants getting the right people that really can step up to a very difficult task.
And I would argue, potentially, we say we're going to get sued, and I think that's probably true. But if we have very, very good legal representation during the line drawing process, we could have the state could have lower legal costs. Because while you'll have some unhappy people, hopefully the lawsuit will be not a very strong, long, protracted lawsuit. So it really is a trade-off in this kind of thing. I think we should have a higher figure here. I would like to have a higher discretion than the 150, frankly. If we were to sort of do a no more than. And that doesn't mean we go there that high, but it would be interesting for us to, and I think it could be an internal figure, and then we hear proposals from people.
Well, we don't have to tell them what it is, but
That's
they'll be
what I
able to
mean.
find it. These are all.
Oh, yeah.
ultimately,
But I mean,
yeah.
we don't have to say in the document.
Not in this
Yeah,
document.
in the-
That's correct.
right, in the
And they
document.
probably won't know what it is.
Right.
So the way it's budgeted right now, there's, I guess, I wasn't paying, I'm not on the budget committee, but I was sort of listening in, but it looks like there's one position is a contingency position, but the total budget here is, over the 2 fiscal years, is 300,000, which is a healthy number, but I'm not sure if that means 2 people, then it's another thing.
I would want to check with Dan about how he's constructed that number, because we may want to report out tomorrow that you'd like to see an increase for simply fees. And I'll double check with him tonight and let you know how that's in there.
Okay.
Yeah, I think we should ask them for an estimate. I mean, we've laid out what the tasks are. It's really like a bid. Here are the tasks. Here's the time commitment. There's a general counsel, there are commissioners, but I mean, have them put together a proposal, given what's laid out, and maybe we need to be a little more precise but I think it's pretty,
Right, and we can always come back and say, well, this is what we have.
Yeah.
Yeah.
How are you with this
Well, I
figure?
think, I'm sorry, I didn't mean to.
No, that's basically it, yeah. Just,
I certainly we can ask them. I think I did, but we can make it clear for a
Yes,
range of
everybody needs
fees.
to
For example, what will you charge to attend a line drawing meeting? Now, if we have 10 or 8 or 15 of those, that's a flexible number.
That's right. That's right. We have a certain number of those meetings. I mean, we have a high end. It may be lower.
I think we probably do need to end up with a not-to-exceed number, but it's the components underneath that are...
That they can use to make up a budget to present
and
to us. And we do have those. We have commission meetings, outreach meetings, input meetings.
What we'll do when this is done, then we'll turn this into an actual fee agreement. So when we have our top person or firm, we can have a more specific discussion about fees and work those things out. But, it's all really, this is the pipe to get there, and it needs to be pretty close.
And so then the only question for us other than that is, do we feel we want to go back to the commission and ask for an increase over the 150, which my instinct is yes.
yeah, or if it's 300. Maybe Dan...
Where are we looking?
Well, I'm looking at, under page 2, under contracts, about 8 lines down, or 7 lines down. There's voter rights attorney hyphen line drawing, and then second VRA attorney contingency.
112.
So I'm not sure what that...
That's 112 more. So you've got.
Can you check that so that we can?
I asked Carol if she could ask if Dan could come across the hall.
Oh, that'd be great.
Yeah.
Because maybe we can just figure that out and we go back with a.
Combine them.
Okay.
And you get a much bigger number.
Yeah.
Okay. While Carol's doing that, I'm trying to figure out if there's something we can knock out real quick. Probably not.
What about the Robert's rules? We can do that quickly.
Yeah, I have a proposal.
Okay, good.
I spoke to Connie about how we might make this an easier meeting than the last one. And I don't, just as an observer of this process, I don't think it's really a Robert's Rules question. I think there are a couple of fixes that could really make a difference. So first one is this. When a motion is made, we will ask Janice immediately to repeat the motion to the commission. She seems to have a talent for that. I think she's really very good at capturing it. And if there's confusion, we can fix it right then, before the discussion starts.
Okay.
So at that point, everyone will be talking to the same thing. And hopefully, if there are amendments, it'll similarly make it easier for those amendments to be documented and read back to the commission. And I think it was that process of lack of clarity about motions more than any other thing that made the last meeting difficult. So she's going to implement that procedure at tomorrow's meeting.
Is it possible, not for tomorrow's meeting, that as we do this, that there is a screen that she can type and the text will appear on the screen? Rather than read back, just make so we have only oral, so for those of it, for people who are visual? I don't know.
I mean...
I mean, certainly there are a lot of things that are possible, but I don't think that that expense-wise or for capability is probable.
It had to be something we sort of had, already.
And the other thing, and I know I talked to Connie, Commissioner Columbus-Camilloy about this. I think there should be also, and maybe people don't agree with this, a clarification that even if somebody didn't follow the Robert Rules of Order to the letter, that doesn't mean what happened is invalid. I think there's some kind of sense of that, and sometimes we vote on something and everybody knows we voted on it and what the vote was, and then we go back and go, oh, but that wasn't according to the. And I'm not advocating for people for people to be sloppy, but I think we also need to not go overboard.
I'll be martinets.
On that kind of stuff. And that's just more of my own clip. If you could, when you report back tomorrow, if you could include that in your comments.
Oh, that does not.
That's not. It doesn't invalidate your vote if there's some glitch with the Robert Rules of Order.
And I was looking at the act, and I was looking at the act, and then maybe this is an omission too, because maybe the Bureau of Audits was just going to defer to the Commission to write their own rules. But the act is actually now currently silent as applied to the full Commission on having to use Robert's rules. The applicant review panel and the first 8 were supposed to follow it. It's now silent. So unless there's some other state law that says you have to follow Robert's rules, we're not bound by Robert. But of course, obviously we want to have orderly meetings, so I'm not saying we should follow them generally.
I also think that it might be useful to come up with a little card for the chair that sets out, if you have a motion, you don't discuss it until you have a second. I mean, you can't talk about it. And only then do you reread it back, because without a second, it doesn't exist.
Yeah.
But I think we break down there, and then if you have an amendment, you have to have a second to the amendment, and then you vote on the amendment. So it's a little clearer for the chair, because frankly, at the end of the day, you're tired, and everybody's talking, and you begin to lose control of what's going on. And so to have that, I think, would be helpful. And then where you have public comment.
So I think this is great, and as part of your report tomorrow, maybe you can include this suggestion?
Yeah. She'll actually kick things off, I think, by
doing it
this way.
Wonderful.
There's one more point, but maybe we can
we can go. So our question was, we're getting to the fee arrangement portion of the request for information for legal services that we're going to post.
Right.
And we are trying to figure out what is in the budget currently. There was some confusion about the 2 items there, line drawing and contingency. And so what have we really budgeted for this position?
Okay, so for VRA, we're looking at 2 $150,000 budgets. So you've got the 75 and 75, and that's where I said they really should probably be pushed into the next fiscal year, because that's how they'll be paid out. So we have 300,000 done, arranged for that, and then the other contingencies. Did you want me to
Well,
No, so-
when talking about the contingency, because again, it's possible we might have two attorneys, but we might just want to go with one, and then we're done. Does your budget, does that second line item contemplate some backup or was it, in case we wanted two positions, there's the dollars to pay?
You know, I put it into this budget to be descriptive, and it was to strike the thought that if we wanted to, this was where we would put the money. It doesn't necessarily have to say second VRA attorney. It can be, just I think it just a kind of a council contingency or whatever, or a legal contingency. I think that we need to build into the budget some ability to react if we need to additional staff if it's necessary, or an additional opinion. But so we can't be caught up on this. This was just to strike a conversation. We can call it whatever we wish.
Just to ask the question differently, if we ended up with one firm, but the total bill was $225,000, this would accommodate that?
No, we would. It would be better if we rewrote it. Not to say a second attorney. Like I said, it was just to bring the conversation about. So it would be better if we had it as, if we called it something else. If we just called it
Voting rights legal services or legal contract, voting rights legal contract, and that could be two people or one person or
sure,
whatever
and combine the two.
and combine the
Just
two.
make it 300,000.
And have a whatever that adds up to, $300,000 line item budget.
Mm-hmm. Yes. So is that what we want to do?
Yes.
Yeah.
Okay. By the way,
Well, we recommend.
Okay.
We're going to recommend to the commission that we do that.
Yeah, we might finalize. We'll try to work out the number too. I think we might want to.
on the Robert's Rules of Order, by the way, it was I sat in the meeting when you were saddled with Robert's Rules of Order, and it was just the thought that there needed to be some structure provided, and it seemed to be at the Bureau the logical thing to place in there.
Right. Okay. Great.
And I have one more question. Did you, or is this the proper venue for commenting on the extra consultant services?
Not yet. We're trying to
Okay.
wrap up on the voting
We're
rights
done?
attorney item. But, great. All right, so we'll recommend to rewrite that to be less specific about an attorney or two and legal contract.
I liked your legal services.
Legal
Yeah, that sounds
services.
good.
Yeah, and then we have a approximate 300K. Okay.
I think that's a good change.
All right. Okay. So are we comfortable with, or do you have more on this item? That's fine if you
On
do.
the procedures item, yes.
Yes.
The other thing I would recommend is we be a little bit more orderly on our public comment. And I think there are a couple of things we can do. First is announce clearly that it's a 5-minute maximum, which is pretty generous. The commission may at some point want to think about a 3-minute maximum. Then there's the manner in which comment is taken, which is a little trickier. The Bagley-Keene does say you need to receive comment before taking action on an agenda item, which is not quite as neat as just taking it at the beginning of a meeting or the end. Now, theoretically, I guess you could scoop it all up at the beginning, but our agendas are not yet at the precise enough to really make a good case for that. But if we know that we're going to accept comment before we vote on a motion, we would at least have clarity about that.
Right.
The other thing is
Yeah.
Commissioner Anchetta mentioned in passing a moment ago, which I think is very important, is that if comment is taken at the committee level and the same item then comes to the full commission in substantially the same form as it was discussed at the committee, you don't have to give a second opportunity for public comment. And I think that will probably embrace a number of people who will have had an opportunity to comment at the committee level. You don't get two bites at the apple.
Right. Great. So you'll report back tomorrow on that?
I will, although, as I said, I've gone over this with tomorrow's chair,
Okay.
and hopefully she'll clarify this at the outset of the meeting. If you'd like it as part of our report, it can do it then as well.
Can I ask a question? This is just a clarification based on some observations. I've noticed that when we have public commentary, there's essentially a silence from the commission, and I don't know if that's been agreed to previously or if that's a requirement that we can't ask a question, even just for sort of clarification. I can understand not wanting to say confront a commentator, but if there's a question about, well, I'm not sure where that line is that you're suggesting, or what does that figure mean? Then again, maybe people just don't have any questions, but I've noticed that there hasn't been any sort of interaction. And is that because there's a rule or
Before
something?
we go there, I did promise the public.
Oh, I'm sorry.
After
Yeah.
the first two items.
Oh, sure.
That we would take public comment. And I think we
Okay.
can, I'd like to.
So can we ask them questions? Is there a rule? Well, is there a rule?
So I will really do this, I promise. There has been a understanding, and it predates my term on the,
Okay.
that we could not engage in a back and forth with the person who makes the public comment.
Okay.
My understanding is that doesn't preclude a commissioner from asking a question. So somebody says something, you say, you can ask for clarification on a point, or to further explain it, or to give you a statistic. But I think what we're trying to avoid is somebody says, you haven't really done this, and you say, yes, we have, and that an exchange.
Okay.
But I think we can try and get more information from I think the gray line, if people agree, my sense of the gray line is when somebody says something and there's some of us may want to say, well, I really disagree with that because at the 2 meetings ago we did blah, blah. Or I really agree with that, we're going to try and do better.
Yeah, and again, I apologize because I was more recently named to the commission. I don't know if that had been discussed previously or not.
The one thing I think would be helpful, or what we could do it, and it may save a lot of grief overall. We had an occasion at Claremont where a person simply misspoke at the microphone. What they said was not the case. Rather than just let that sit there, to have the chair, and it would be the chair to do this, to either respond. I mean, the particular case was that the legislature has the final say. That was an untrue statement. The chair could have corrected at that time, or directed a question to the council and said, the speaker made this assertion that the legislature has the final say. Would you please clarify that? And do it that way. Get that off the table, because it's like the retraction is never read. It's the statement that's read. And so just try to, things of that situation where something is incorrect.
This is something that the commission had asked us to put on our agenda for clarification.
Okay.
Because there's I think a range of things that people understand as permissible.
Right.
And I don't know if this is something that off the bat, or whether there's something that you should look into. I don't know where,
I was just curious where it came from, that's all.
There was a training apparently that did go into this.
I don't believe there's anything in Bagley-Keene that precludes you from responding. It's I think more of a best practice.
Sure, that's fine.
And particularly, the form of asking a question for clarification, I don't have a problem with doing that, as opposed to getting into the back and forth about an issue.
Okay.
But there was a training apparently, like I say, predates me from when the first 8 commissioners were seated. They had some training.
And this will, I promise, just take a second.
Yeah, yeah.
We are going to offer or provide additional training on Friday. So, and maybe I can just get a quick list from you. I'll tell you what. This is what occurs to me are the key things that we need to talk about, rather than the global view of Bagley-Keene, which would be the challenge of serial meetings, procedures around any closed sessions, and proper ways about noticing and creating agendas for meetings. So those were the topics that seemed most pressing to me. Are there other questions that you'd like addressed?
Let me look at my notes, because there were some issues on this that...
Well, actually, something comes to mind, which was when I was trying to look at how we were putting items on the agenda, particularly for advisory committee agendas, because I don't think we have we don't really have a chair per se, or do we have a chair or a
For
rotating
these?
chair? Yeah, for this?
Yes.
We do, okay, so.
Well, we haven't necessarily named them, but the idea is there.
Well, yeah, well, okay, that's good. That's good to know.
There's no incohate chair.
That's good to know. So I raised a question, and I think Mr. Claypool didn't get back to me immediately, so I was asking at least one commissioner about that. And then I simply went to the chair for the whole commission for this set of meetings and just had her do it, which I thought was probably maybe the best way to go anyway. But I guess one question that sort of came up was when you're working with the committee, and this goes to serial communications and those kinds of things, what can you actually talk to the committee members about? Because I think there were probably some times when we were talking with the VRA Council where we were probably going, and I think I said in an email, we have better stop this email, because I think we're actually communicating among three of us now rather than just two of us.
The issue plays out the same way at the committee level as at the full
Right.
commission because of the definition of what is a state entity for Bagley-Keene. But we can address it in both contexts
Right.
because it
Right.
feels different.
Yeah, because I think, again, we're trying to get work done within the
Right.
committee, but we still have to comply with Bagley-Keene
Yeah.
generally, so.
Yeah,
yeah.
I think that would be great to include that. Right. Okay, so we'll take some public comment, and then we'll take a brief break.
Sure.
And if people want it, no break?
That's your public comment.
Okay, that's after public comment. We're now taking public comment.
You have a microphone here.
There's a mic there.
The mic is active.
Let's make sure it's...
Hi, I'm Deborah Howard, and I am I staff the California Chamber of Commerce and other statewide business organizations tracking the commission and its work. I actually watched every one of the interviews and every one of the trainings that was offered to the commissioners. And I will say that there was a Bagley-Keene training where they basically said, you are not allowed to talk to people when they're making public comment because it's not agendized. And I think that it's been, I'll just speak from the heart here, it's actually been kind of frustrating because when people make comment that really is to an issue that is on the table, it's like it's like we're talking to a blank wall. There's no recognition of that, yes, I heard your comment, and thank you for that perspective. There's nothing about that changes anything that we've known until this time. So I actually think that the public that is engaged in this would be very encouraged to have just a sense of feedback. Was that helpful? Did that add something that you didn't know before, even if it was something that from a perspective that you had not been given? And I guess that's really the core. Commissioner Forbes was in the earlier meeting, and I talked about the issue of transparency. It's been pretty frustrating, I know from your perspective, that you don't have the tools you need to be as open and structured as you would like to be. There's no office. You went from having the state auditor basically basically promulgating the regulations and saying this is how it's going to work and making them work that way, to going to the Secretary of State's office who said, I don't want to staff you, and, we're just going to put up with this until you get your staff, and if you could do that right now, that'd be great. So I kind of understand where you are from somebody who did watch the entire process. It's really hard to be a part of this discussion and report back to people who are passionately interested in making this work when we don't have the documents you're discussing, such as the RFI in front of you. There was this issue this morning in the Technical Advisory Committee when they were looking at hiring the consultant to draw the lines. This is the other key piece of it, and I know that you all are aware of the chatter between Bruce Kane and Tony Quinn on the redistricting and all of that kind of stuff. It would help to make, so it's not just having that document, but as your discussion talked earlier about making sure that what can be public about that process is made public. And I offer to you the model that the state auditor made in all of those promulgations. There were 30,000 people who submitted their names to be part of this commission. How they shared that information publicly at different levels through the process was really pretty remarkable. And I think from that model, this commission, you all are equally smart, and approaching the problem in a similar fashion, you could come up with equally creative and appropriate responses to that. Because the key hiring, we love Mr. Miller, we love Mr. Claypool, we think they're going to be fabulous, but the people who will make this work will be the person that you hire to draw the lines and your voting rights attorney. And if those two hires don't instill the confidence of everybody who's watching this, we're going to have some serious trauma, and we don't want that to happen. So again, allow for that comment, take those perspectives into account, and give the universe that's watching, which is a relatively small universe, as much input as possible. Thank you.
Any more public comment? All right, well, if folks really don't want a break, I'm just going to keep taking us through. Okay.
Because, I have to leave at
What
5
time?
o'clock. So
Okay, so, all right, so then definitely, so, did we want to have Carol present now, or?
Actually, I don't.
No, there's no need?
I think I was here just to provide clarification.
Okay,
as necessary.
all right, okay.
But I wanted to, do you need me further?
I don't believe so.
Okay. And I'll call you later, and I don't think we have any problems at all.
Okay,
Yeah.
great.
Can I ask one question? I know obviously in the line drawing consultant, there's a very elaborate scoring system, and we're looking at something that's a little fuzzier here, but in terms of criteria and how we're evaluating and...
Yes.
Yeah, I'm sorry. So, and maybe this is also to Mr. Miller, but just in terms of how, given how we're evaluating and ranking our top candidates, is this pretty much at the level of specificity we need to get it through, or do we need to get more specific here?
May I see what it is? I actually don't have the final copy of
Okay.
this.
Because again, unlike the line drawing consultant, which has a pretty detailed scoring system, this doesn't. And I don't feel we have to have a 0 to 100 scale, but we should have some agreement among the committee members, at least, that this is what we're going to emphasize. And obviously, they're built into what we're asking the candidates to produce for us. But we're not sort of either weighting one area more than another, or. And I'm happy to leave it as is. I'm just wondering if we have to have any more specifics in it.
So you're saying that the request, sorry. So we're talking about the statement about fee arrangements?
Not specifically. Again, it's more of a question of, is this ready to go without our putting either any kind of numbers in there in terms of, scoring, a scoring system? We'll have to have some discussion, obviously, in terms of what we're going to consider, but do we need to elaborate that in this document so that both the public who wants to comment on it as well as the potential bidders know what we're going to emphasize?
If you've included all of the requirements, that is what you want this attorney to do. Have you clarified that? These are the things you want. These are the services that will be provided. That's what you need to do, and that's what you need to be thorough on.
Okay. Well,
Because they're going to come back with a fee arrangement, and it's going to address what you've said you need. So if you haven't
Right.
included everything you need,
right.
you're in jeopardy of not getting a price for what you need, and then you're going to have a resulting contract, and that contract needs to include everything you need. Now, right now, as you've written it, you're just saying, tell me what your structure is. You're not in a competitive bid environment. This is not a bid. This is literally you going out and saying, I want this information so I can assess it. So you have a lot of liberty to make an award based on, well, frankly, you can even the contract doesn't have to include just what you have here. You can add more after you've talked to this applicant.
Okay.
So it's not a bid. You're not limited to just what's here.
Okay. That's great.
This should just get you all the information you need to make a decision.
Okay. Sounds good to me.
Are you okay?
Great.
Yeah.
Thank you.
Thank you. I have, before we go to this item, there was another item that's been also trailing for a while, which is the issue of how we define redistricting matters.
Okay.
And I know this is really, people are antsy to have this clarified because we're all continually invited to speak, comment, et cetera, at different venues, and we want to know what we can say, what or we can't say.
I've been working with Rob Wilcox on this, and he in turn has been doing one-on-one coaching with commissioners on the subject. Here's how I look at it and how we've been approaching it with the commission. We'll see how this hypothetical works with a group of lawyers. I look at the language in the Act. It says, commission members and staff may not communicate with or receive communications about redistricting matters from anyone outside of a public hearing. I look at that kind of like a jury instruction, and you're the jury. So within that context, there's a couple of things. You can say you're on jury duty, right? So I think that gives the commission latitude to say you're commissioners and to describe what the commission is, that kind of background information. I think it precludes the commissioners from commenting on outcomes of meetings or people that appeared before them, precludes them from talking about a map, essentially evidence before the court, precludes them from talking about what might happen in any particular district. And in the larger sense, I'd add the other instruction that you get, don't form any opinion until all the evidence is in. And maybe that's the most important piece. I think that language precludes a commissioner from offering opinions about anything. So that focuses any comments on the objective process that's described in the statute itself. It tells us how to go about our work as a commission. And I think people can say that and say that that's what they're limited to is background, and then the process is as is in the statute, as opposed to trying to interpolate that or explain that further. So on the one hand, it's limiting, but I think we do have to give deference to this very strong language while giving people a path where it feels like a safe harbor and they can comment.
So let me give you a gray area.
Sure, that's where we live, right?
So you're interviewed by a newspaper, TV, and, Commissioner Blanco, yes, it's wonderful. We have a great team. Yes, it's very exciting work. It's, groundbreaking, very exciting. What issues do you think the commission is going to be facing in the next, as it engages in this first of its kind Citizens Redistricting Commission? Well, We hope that we can address what the voters wanted us to do, which is to, draw fair and impartial lines. Gray area. We know that there are areas that are going to experience big population growths, and we'll have to take that into account when we look at where.
I wouldn't go there.
I wouldn't
Okay,
go there.
right?
Nope,
No.
that's not gray.
I agree. I agree. That's not great. So really, we're talking about.
No, I think, one of the things you might do is say, look, the Act gives us a real roadmap to follow. We're going to be conducting public meetings. We're going to offer education. We're going to receive a good deal of input. We're going to take all that into account, and we're going to do our best job to apply the process as described in the statute.
Yeah, I've been asked that question. I was asked that question today.
Yeah.
And it was basically that the challenge we're going to face, to be sure that the public feels that the districts are fair. Mm-hmm. The public feels like they've had an opportunity to participate, that we are able to get the public to participate. Those are the kinds of issues that, and we have a short period of time and limited resources with which to accomplish this task. That's our challenges.
I agree, and I think that actually the information about, we're looking at trying to go to as many regions as possible, and and we're looking at potentially, because this is all public, it's not a comment, it's, we've been looking at how many regions, how many can we really travel to given our size, but we're trying to maximize, our outreach because we know it's a large state, and I think the more you can describe the process.
Right, that's what you do. We have
That's
a website,
what you do.
we have a Twitter account, we have a Facebook account, it's an opportunity to serve those up.
I agree, I just, yeah.
It is a challenge to have all 14 commissioners agree and hear that in the same way, but I think that's what the drafters must have intended, is no fact-based statements about drawing lines.
Mm-hmm. Okay.
Or opinions.
Has there been, I guess and I think I was looking at transcripts from prior meetings, and this is where I think on the other end of it, which is the receipt of information, I had a disagreement with what was being decided, or was, at least at that point, it was an interpretation, which was you couldn't even go to a training, for example. I understand that if you go to a conference, depending on which conference it is, there may be certain leanings or certain types of districts that people might be wanting to push for, and I think that's appropriate maybe to sort of abstain from those kinds of things. I think we've had a couple commissioners give welcoming addresses and then off they go, and I think that's fine. Not sending somebody to the National Conference on State Legislatures training conference, I think was not a good thing to do. If we could have sent somebody there, because that's a training conference, and I think to the extent we get information, whether via staff or via representatives of the commission, that it's important. And again, we have to review what the content is. I think I'm not saying we shouldn't do that, but it seems to me that it's a very cramped interpretation if you're saying you can't get trained on key issues that will ultimately be in front of the commission, as opposed to things that actually would be redistricting matters that will, of course, have some influence on your decision making. Because I'm concerned that we're not turning into a black box either in terms of what we might be hearing.
And along those lines, just out of curiosity, I'd like to read some of the Supreme Court cases you've made reference to.
Right. And I don't think that's precluded.
Can I do that? I'm getting information on
communications from anyone,
not in a public hearing.
If you take a very the interpretation I've heard via the transcripts and some of the videotapes, it was that sort of interpretation. The answer would be no.
Yeah.
I don't interpret it that way. I think we should be clearer about that. But I would open it up to a bit more in terms of what you can be exposed to as a commissioner.
I would like to get some clarification about this issue. I'm sorry, I'm not going to not read legal opinions about redistricting.
Yeah. Mm-hmm.
When we're doing redistricting.
Right.
And we're going to be trying to, and it says our second criteria is the Voting Rights Act. Well, at least I hope I will have read the act and and hopefully some decisions interpreting the act. And that's my mandate.
I suppose you could take the position you can't read the proposition.
So, but I think there is obviously a spectrum, but I agree with you, there's lack of clarity about the receipt of information. Somebody sent us information about a webinar on the census, and people said, oh, we shouldn't participate on this webinar. Participate in terms of not being a presenter, but just, listening to a webinar. So I don't know, I know we've talked about this, and I think you were supposed to be kind of looking, I know on the redistricting matters, you've given us your thoughts. Had you looked at the receipt of information component?
Well, I'm not sure how to pursue it other than to literally try to find the drafters, which may be a possible thing to do here. To me, a common sense reading would be that they intended to preclude any discussion with, let's say, the lobbyist from Santa Clara County or a supervisor from Yolo County about that district, that kind of specific information from someone who may have something at stake, as opposed to a national seminar on the subject of redistricting. I think, I don't know how else to go about it except to see if we can find a drafter or craft what we feel is a very fair reading that could not prejudice any portion of the state.
I think we should really urge, I think people need this. It would be very helpful if you could come up with a recommended interpretation of this.
I sort of think in terms of, I've struggled with this myself, is that insofar as it's going to make me a better commissioner, as if it's something that is going to be a general piece of information or approach that's applicable to all the districts, that's probably something that I want to know. And because that'll make me I'll do a better job. If it's stuff about, as you said, like I got a question from a local paper about a particular congressional seat, which happens to have this sort of odd bulb. I said, I'm not going there. I can't talk about that. And I don't want to hear about it, except, formally.
So our preliminary response on this has been to work up a methodology that Rob Wilcox is reviewing with each commissioner.
Okay.
It may be that we need a deeper dive after that, particularly on chasing down the receipt of information.
Right.
Our leading edge, if you will, has been on speaking rather than receiving.
Correct, but I think we need the receipt. And I think it will end up being, actually, my sense is a little bit even broader than the discussion. I see this as really precluding nobody should give you a map and say, look, this is how here, Commissioner Blanco, this is what I think you should do in San Joaquin Valley.
I think
but if somebody, if somebody recommends an article for me to read, I can read it and use my own judgment.
I think it would be helpful, perhaps the phrase might be give the commission some cover. If you were to draft a memo on this, that was an official opinion on this particular question, so we could then, so for us, this is the legal advice that we got.
Yeah.
Rather than have this.
Okay.
I need to go to my store.
Okay. All right.
See you tomorrow.
See you tomorrow. Thank you. The last item is the item raised by Commissioner Antai about beginning, and I think he had also asked for you to look into this. I think we should talk about it. I don't expect for it to be resolved yet. But the issue of what happens if we're at a input meeting and not let me put it this way. His question was, we have our first draft of a map. We go out to a particular region. We get comments from the residents in that region about the map that affects their area, and not all commissioners are present to receive that feedback in person. When we go back to the full commission meeting and are making our decisions, can the people that weren't present from the commission vote on that?
And there wasn't a quorum at the what's the number of commissioners who were present at that first meeting?
In his hypothetical, I don't think he specified quorum or no quorum.
Yeah. Well, I don't have my initial reaction is I don't think that would preclude action by the full commission. That I think at some point we have to. Not everybody can make these meetings. Again, I think we want to endeavor as much as possible to have everybody at that stage, have everybody attend those meetings, but that conveying information either by reviewing transcripts or tapes or having some discussion among the commissioners who did attend so they could, the other folks, during a public hearing or meeting, getting them up to speed would be sufficient. I would think that we wouldn't have to sort of not vote on it because we didn't have either a quorum or a sufficient number of some level at that first meeting. That's my initial take on that.
Yeah, I don't. I think his concern is this is a formal hearing so it's like a meeting of the commission. We've formally set it. People come, they give us their input. There's a give and take, of asking questions, and then we go back. My instinct is as yours that, I can see a commissioner feeling like they might, if they weren't there, maybe if they're torn about something, they might, I don't know.
They can always abstain,
They can
too.
abstain. That's what I was going to say. But
we do have a problem, of course, given our majority requirements.
Right. But I don't see what law or reg would preclude the vote. I'm trying to think really carefully, and I can't see what it would be that would preclude us from voting if we weren't present. We can review all the material. We have transcripts. We have, we can, everything. Plus the comments of our fellow commissioners. So I'm not, and our attorneys.
Right, and staff.
And staff. So I'm not really sure. But I know he did raise this and ask for us to consider this and report back.
Well, I think your analysis is correct, first of all, and the number of commissioners at the meeting I don't think is an issue. You need 3 to constitute a public meeting. I can't imagine any map will be approved except by the full commission. So even if you have a quorum at a meeting, it's not really a quorum for the purpose of taking action on a map. I guess one question we haven't discussed and we'll have to face at some point is, will there be voting on individual maps, or is it going to be like military base closing, where you vote on the entire slate, in which case that answers the question. Either every commissioner has to be at every meeting, or you can't vote, and that would be untenable, of course. So I think you've answered the question correctly, but the next question to me becomes how to have the best discussion with the commission if there are differing points of view on this.
I think what I can do is when I report back tomorrow, maybe I can just draw Commissioner Ontai out a little bit about what to try and identify a bit more clearly what his concern was. I can tell him what our initial reaction is, but then probe to see what specifically was the thing, the reg or the law that he thought we might be stepping over if we voted without being present, and maybe that'll.
But okay. Yeah.
No, go ahead. What?
Well, it just I think the fact that it all comes back home at the end, if you will, is the answer that the full commission.
I see what you're saying. So maybe we can. I think that's right. I mean, even if you did vote assembly by, I can't even imagine what it would be. But let's say we figured out some way to do that. We submit a final map. I mean, that's really what ultimately we decide to submit on our due date, is a final map with everything in it. So that would mean somebody who wasn't present at every single, both the map meetings where we take out maps and get a review and come back, couldn't vote.
I think everybody on the commission knows the numbers that we need to finalize the maps
Right.
and pass them. So, again, there may be circumstances where we have a smaller number of commissioners getting all of the information that you might ideally want to have. But I think as long as we feel confident that a quorum, or at least a sufficient number, can air out all the issues that other people who miss parts of the public testimony or were absent from a particular meeting, or feel that they can make an informed judgment. And again, I anticipate that we will have a few people who just can't make every single meeting. I think as long as people feel comfortable that it's been talked through and that they have a good sense of what happened when they weren't there, that we wouldn't have any people abstaining from the vote. Because obviously we do need that supermajority
Yes, right.
to pass the maps.
Okay. So and then, if there's disagreement with our take on it tomorrow, I'm sure our fellow commissioners will express it.
Okay.
I am looking at everything that we said we would cover.
You asked me to prepare a policy on disclosure.
That's right, and this is the last item, is the disclosure policy. So everything else, am I missing something before we go on to this last item?
Yeah, I think so.
Okay, great. So you want to describe this for us and your thinking?
Sure. Well, this was just to formalize the concept.
This is a very curious spelling of redistricting, but that'll be corrected.
Let's get that corrected. Yes, I'm still practicing that.
Really?
Both orally and in writing.
Anyway,
It's to memorialize the concept that when someone is acquainted with another and they're being considered for a service, and this is, could well come up in the VRA context, that a commissioner would advise the commission of whatever the nature of that. I'm calling it a relationship, for lack of a better word. The fact that you know somebody from whatever experience. It is
Yeah, relationship's a little, yeah. And then following disclosure. So my initial reaction to this is that it sounds fine, and then I wonder what it will be like in practice, when I look at it.
now under this wording, the commissioner will disclose this, and then we'll probably have some discussion at a meeting. Ultimately, the decision to recuse, and I think it's just recusal here, falls on that commissioner to make a call on that, as opposed to the commission by vote saying you should be recused.
That's my question here. It says a commissioner shall determine in consultation if that requires him or her to recuse themselves. And I'm not sure what that looks like in practice.
Well, this is why we have these discussions. The concept was, I didn't want to write something that required a commissioner to
recuse.
abstain.
Right.
And so that's the concept here.
Right. So we're trying to not have a bright line rule.
Right. A mere fact of being acquainted with someone, these are opinions. I'm offering an opinion
Yeah,
here.
yeah.
To me, didn't seem like a reason to require that commissioner to abstain. So this permitted a kind of case-by-case judgment depending on the nature of the relationship.
I guess the question I would ask is there any scenario where we would want, or we'd want the commission to make the decision, well, we really think in this particular circumstance you should recuse yourself? Because that scenario is not covered here. I put it out whether, I mean,
Right.
I don't know if I'm kind of agnostic on this particular matter, but there may be circumstances that do come up where, again, the rest of the commission feels, well, you really shouldn't be voting. The actual commissioner says, no, I think I'm okay. I should vote. And again, maybe that doesn't come up. Maybe it does. I'm not sure, but that's not here clearly. So I don't know if that raises enough concern for folks.
Yeah, I just don't know that this achieves, it achieves partly what people want, which is a policy of disclosure. And I think there's no doubt that everybody wanted that and we didn't have one, and this gets us that which we didn't have. We might tinker with it in terms of relationship and whether that's the right word or, but I think we could get there, right, in terms of what rises to the level of something you have to disclose. If you've been at a meeting, does that mean you disclose? And in any event, I think people should always err on the side of it anyway. So we could figure that out, right? What's trickier for me is this other, like you say, because I agree that we should not. My sense is that we don't want a bright line kind of rule that requires recusal or abstention. It may actually be very helpful if somebody, it's hard, we always think of knowing somebody as being a negative potentially. But knowing somebody, the reason you recuse yourself is if you think that you can't, that somehow you're going to be biased, and it could shift. And it's the ultimate scenario is it's close. You're biased. And you're the vote that could have made the difference. But what if you know the person and you actually have really important negative information, right? And if you voted, you were going to vote no, right?
Well, it's bias in the other direction.
I guess it's fine, but you know something that actually is really important.
Yeah.
That you feel would have been important to
right.
be able to vote no. Because,
and I think that's helpful information for the commission too.
And it's helpful information to the commission. So you disclose it, and then you say, but I'm not going to vote because I do know this thing that's actually pretty damaging to this person. Well, maybe, but it's kind of. And the other thing that worries me is that the closer we get to these things like the attorneys and the line, and this is, I know for me, a personal issue, personal/professional issue is all of us on this commission to some extent have been in the world of voting or elections or redistricting. We'll know at some point, or even people who have done work with organizations that do civic engagement and promote civic participation, because a lot of these people also work in the civic engagement, civic participation side of things, are going to know people. So then it's a question of that's why I would agree it shouldn't recuse you, but then I don't know if then it rides on the nature of the relationship. Yeah. In contracts, what you're trying to do is avoid, trying to steer something of the way of a friend. And maybe that's what we're talking about here, right? That if you have either a business relationship or a personal relationship, we want to avoid any sense of steering something. And that's sort of what the rationale is. So,
look, just throw out an alternative approach to this would be, in lieu of the second sentence, to say something like, following the disclosure, the commission shall make a determination about whether the commissioner should abstain from voting. So it places then the burden on the commission directly to decide.
I think that's cleaner than leaving it up to the commissioner. I mean, like, what are you going to say? Well, like you say, I've heard everybody's opinion, and I disagree, and I'm going to, I'm not going to recuse myself.
Then it sort of forces someone to say, well, I'm going to move.
Yeah. So I think that is actually a cleaner way of doing it. The only thing I feel a little bit, I feel gets left a little gray is determine if the relationship or knowledge requires them to be recused. I don't know what that would be. So what guidance are we giving to the commissioners, right?
Yeah.
As to when they should insist on recusal. I mean, it's a pretty big burden to put on the commissioners, that if somebody says, I know this person, you're going to say, you have to abstain. So if we're putting that burden on the commission to do that, what it should be their guidepost for when it rises to the level of insisting that somebody recuse themselves. That would be the only thing that I feel is a little, I mean, I can see this creating problems, that to have that lack of.
I'm hoping, I think it's okay as we just amended it, but I would think or hope that there are some either formal guidelines or at least some precedents from some sources that allow us to say, well, what we're talking about has been sort of fleshed out somewhere else. So we're talking, if there's a family relationship, you want to disclose that. If there's a business relationship, if there's conflicts of interest, that kind of thing. Those have been, given that this is not the first time we're encountering this problem, that we can rely on some past guidance from some source.
That makes sense. Just the larger picture is the commission seems to want to know if you simply know the person, which is greater than the legal conflict that you're suggesting.
Right.
So I wanted to scoop up kind of the universe of any contact. Intentionally drew it that way, that any contact needs to be disclosed, because that seemed to be the sense of the commission. It begs, it doesn't get to the question. Maybe we could go on and say, financial, family, business relationship, but
I think, again, and this is, it's written as a disclosure policy, and I think that is the gist of what we're concerned about here. So I don't have a problem, again, leaving it pretty much as is, as long as, again, there's sort of a general understanding that I think we don't have to have it all in the disclosure policy, that we, at least if questions come up, we can say, well, I think, it's sort of the, you want your husband to do this? Well, that might be. We have a little concern about that one, and you should tell us that that's your husband, right? But we can figure some of those out, or they may be somewhat obvious. But again, it is a disclosure policy at heart, rather than sort of a recusal policy. But again, I think there are probably some areas where we're going, oh, that's kind of a distant relationship, or it was such a long time ago. We'd have to work this through in the meeting. I'm assuming that let's, and it's come up. Obviously, I know when my own being named to the commission, that how do you know this person? And we can talk it out in the meeting itself.
We could just stop after the first sentence, which creates the disclosure it creates the policy. My concern then was what people would then say, well, what then?
And then what?
Right.
So
Yeah.
just try to provide some kind of avenue there.
Yeah.
So even on, let me just say, even on the first sentence, just in terms of having clean, because these things are what, as lawyers, we've all seen really sloppy, now not that this is sloppy, but, then people go back and what did that mean? What did that? So I think relationship is fine. I don't know that I would say shall advise the commission of the relationship or other knowledge about the, that's, what are we trying to get at?
Relationship is the key. Why don't we
I think,
strike-
the other thing is sort of, because I think you really want to know, do you have a relationship with this person or entity that's seeking, to perform a service for us? And then I would say, on the second sentence, I'm not sure how we should do it, but again, it should be determine the nature of the relationship. Determine if the nature of the relationship. It seems to me what you're really trying to figure out in these situations. Because if you just say if the relationship, I think that gives very little guidance. If you say nature, it kind of begins to say, look, here's what we're really trying to get at, is you need to try and probe what the nature is to see if this person really shouldn't be voting on this because it's the nature of the relationship is one of friendship and they can't be unbiased.
I think that's a good edit.
Yeah.
Did you want to use what I'll call Form 2? Let me just read it and see if this is what you meant. Following the disclosure, the commission shall make a determination about the nature of the relationship.
Well,
it doesn't quite.
Well, it would say shall determine if the nature of the relationship requires the commissioner to be recused, is the way it would read.
I'm sorry, could you read that again, please?
Following such disclosure, the commission shall determine if the nature of the relationship requires the commissioner to be recused from voting on the retention of the person or firm in question. And then that's what the wording would be like, and we're still left with the issue, do we want to actually, is that enough guidance for the commission? The other thing is, it also puts a mandate that you have to make a decision, right? Shall determine if there's a recusal. So once there's once there's a disclosure, it triggers a vote. A mandatory vote. That's the way this is written. Because of the shall. And if that's what we want, that's what we want, but we should be clear that that's what this does. It requires a vote.
Well, you could just change it to may.
I think that makes sense because you could have a situation where something is so minimal, but once you put the shall, it triggers a vote for every single situation.
Well, it could just be, a very, very pro forma vote. I don't know. I don't feel strongly either way. I think, again, I trust in operationalizing this that the commission will kind of, okay, let's talk this out, and then we'll kind of reach a decision on this. But I'm going to
leave it. I think the less we are operating on so many strict rules here that the commissioners, all of us are juggling, that I would prefer to say may, and then, and that's what the commission, that is the discussion. The discussion is, what do we do about this, rather than it immediately goes to a vote.
Yeah, and then if we want to vote it, we can.
And then if you want to vote, you vote, but you don't, it doesn't like automatic vote.
That's fine with me. Yeah.
Okay, so we can recommend that this be our policy, and people may have comments about wanting to flesh out a little bit more what the criteria are. Let's see if this is enough.
Let's see if we can get it.
Yeah,
through
let's see if we can.
let's
see if this is enough.
as prepared by the commission,
Okay,
or the committee.
committee, okay.
I'll make the revisions this evening and have copies available for the meeting tomorrow.
Okay. And I think those are all our items.
It
and
is.
For, we will now take public comment on the business we conducted after we concluded the first two items, which were the discussion about the Bagley-Keene Act and our voting rights attorney selection. Do we have any public comments? Okay, we stand.
Why don't we, just
okay.
for safety's sake,
Yeah.
since it's such an important matter, let's review our pathway to completing the selection of
The attorney?
RA.
Sure. I have my notes and we can,
And, you know,
I get my
you can
calendar
take
out
a breath
again.
and just think about if there's anything further you'd like to see in the request for information as well.
Let me pull up the calendar. Okay. All right, so let me pull up what's it technically called? It's called a...
We're calling it the state lingo is request for information.
Request for information. Let me just pull that up again. Okay. So. Thank you. So this is what I have that we decided on. We will require the SOQs to be submitted by 5 p.m. on the 14th. The advisory committee will do a first cut on subcommittee, advisory committee meeting on 3/15. And then make a recommendation to the full commission when it meets on the 17th.
Well,
No.
the committee will meet on the 17th.
That's right.
To hear presentations,
That's right.
and based on that, make a recommendation to the full commission
On the 18th.
on the 18th, and the leading candidate or candidates will make a presentation to the full commission, and then the full commission, I hope, will make a decision
On the 18th.
on the 18th.
So we will do interviews in the advisory committee meeting of our finalists on March 17th.
Right.
And then take those recommendations. We will ask the candidates to remain.
Now, just as a question, if for some reason, and also we may have given it's only, we're not meeting on Wednesday, is it possible that this could get bumped to the 19th, Saturday the 19th?
I think there is a possibility of
Okay.
that. It's something we need to try to
Yeah.
reconfirm.
Right, so just for purposes of the RFI, we should just, as we're sort of noticing when you might have to be in Sacramento to present, that there's a range of dates you're going to have to
Right.
kind of mark off, and there was some flexibility to it. And as long as I think that's okay with our
So we will
process,
definitely
too.
have an advisory committee meeting on the 15th. That has to be noticed.
Right.
And then we will have another meeting on the 17th.
Right.
That will also be, obviously, a public hearing where we will interview.
Yeah, and then I think, as is the case with all our full business agendas, 18th and 19th are basically just sort of all together, so we can just,
Well,
isn't that typically how we've
it's
noticed them?
It's not the form that we would like to see go.
Oh, we want to be more specific. Okay, that's fine. That's good.
Right.
That's good.
So,
That's good.
so that's the timeline.
One thought just occurred to me. Since the first meeting on the 15th is a public meeting, those who submit packages can come to that meeting. And you have the potential there. Some can come, some can't. They may want to speak to their proposal. So I'm just thinking how to handle that. We might treat it like public comment and limit it to 5 minutes. I don't know if you can. It's awkward to preclude someone from speaking.
I don't think it's awkward. I mean, I'm not at all knowledgeable about, but I don't think that's a public comment. If I were asked my sort of gut legal reaction, if somebody's got a proposal in front of you for work, for business, and you're considering that, I don't think if you get up and speak and you're that person, it's a public comment. I think then you've crossed into another.
You're not taking action. Well, let us look into this one.
Yeah,
Right.
yeah.
Well, I don't think we can preclude anybody from, if we just have the 5-minute public comment period, I think we can preclude anybody, including a candidate, from saying something in the public comment period, but. But
not that we want.
But we can
that,
limit public comment to what we are discussing, and of course, the impression you will make if you try to cram your presentation into 5 minutes will not be a positive one, I think, on the commissioners at that time. So, but I'm concerned about, again, there's this problem of sort of advantaging those who will happen to be here that day.
That's right.
Versus others who won't.
Which is why I think it may be one of those situations where we don't consider it public comment. I mean, if somebody wants to just say, I think you should hire somebody with litigation experience, maybe that's a public comment.
Right.
But when somebody starts to speak in favor of a submission they've made to you for employment, I think that's different. But like I say, I'm not familiar.
Yeah,
that's not quite a public
What
comment.
I'd like to do is flag it as an issue
Yeah.
and make a recommendation for how to deal with it.
Okay.
Right.
I think that's.
The other thing is, in keeping with the comments of one of our speakers today about transparency and trying to perhaps take some guidance from the way the State Bureau of Audits posted all of our prospective commissioners' information on its site. I think that it would be, if we do want good public comment on folks, that we should, once we get these SOQs in, we should post them and invite public comment on them.
Right, and I think that's
Not invite, but just
yeah.
they're there for public comment.
And I think that's been an issue that's come up with the Public Information Committee regarding the problems with the website and shifting over to Facebook. And we can certainly, as much as possible, encourage staff and commissioners, to the extent that they're distributing anything, to have that available as early as possible and posted prior to the meeting. There'll be times when we just can't do that, but I think we should always try to do that. And again, hopefully these problems with posting and quick access to the web will be gone soon.
And we have some guidance, the way that they redacted names and addresses and all identifying information. So that's not difficult to do. We could do that, and still people could know who they are and what their experience and previous work is.
Yeah, I wonder if it would be fair to. We're not obligated to put them on the
That's
web.
right.
Perhaps redacting their budget proposal would be a reasonable thing to do.
Although that might be what interests people the most, is to know what they want to charge. I mean, to me, I don't see the basis for that in terms of protecting people's privacy, like a home address or a phone number. I think it's part of what people want to know is what they charge.
Yeah, I'll defer to state custom on these, those more knowledgeable in terms of what is normal for this kind of RFI.
Does that did this reading back reflect this, what you had in terms of
Yes,
the dates and
yes, it
everything
does.
and the process?
Yes, it does. And then I just wanted you to kind of think, if you will, if there's anything else that occurs to you
Absolutely.
to improve the form of the document, particularly as to the specificity of services. I feel like it's what I could come up with, but I feel like it's more general than I would like it.
I agree. I think it needs to be tweaked a little. Are you going to ask for this to be adopted tomorrow by the full commission, or how do you want to do that if we do want to still work on it a little bit, since given our timing?
It seems to me it would be fair as a report out of the committee to say that you've approved with comments a request for information to solicit services from law firms, lay out the schedule, and stop at that. We can't, I don't think, do much with the document this evening prior to tomorrow's meeting as I can with the policy.
And what was the target date to have this out publicly?
Let's say by Monday.
You're right.
The problem is that we're here and we don't have people to work on it while we're here.
Right.
So, but obviously we want to get it out rapidly.
And I don't think there's a problem with our alerting our networks that, oh, there's something coming out really soon. Be on the lookout for it.
No, and indeed, we will post it on the website. We'll get it into, there is a state system for disseminating these things, which we'll use, and we can send it to individuals as well.
So actually, one thing that might be useful to develop, and this can go through the public information arm as well, is if there's a sort of a 2-paragraph ad basically that can say here's the link to the website and more information available there. That will be, I think, very helpful for us to forward and to get to disseminate pretty widely, and then they can just go to the website and actually activate the system.
Remind me when we're shooting to have it posted or sent out?
Let's say Monday.
28th, February 28th.
Okay.
But would you be comfortable with that form of report rather than going through the document itself with the full commission?
Yes.
Yeah,
Yes.
that's fine.
Yes.
Yeah.
Yes. You can present it. The report is the deadlines. We have the broad outlines of the SOQs, but we're going to edit some more. And the main thing is letting them, I think, I would hit the highlights of what's in there. For example, I think people will want to know, because there was a lot of discussion about it, that we have a statement in there about litigation experience. Because that people, wanted to make sure that we captured that. So I would hit some of the qualifications, but I wouldn't walk through the entire thing. Hit through some of the qualifications, and the most important thing being the timeline and how we're going to do the deliberative process here and then to the commission.
Have you got any further thoughts about trying to capture more specifically the scope of the work? Please pass those along to me.
Yeah. And I think, I can tell you now that I think one thing, especially for them to be able to put together a package, that they may need to know an estimate of the dates that they will be expected to attend public.
What's your sense of the breadth of attendance that you'd like to see?
We're talking about I think the two most important, the last two sets of input, I think the first two meetings where you get the input about everything, neighborhoods, communities of interest.
But this is the line drawer meetings.
Yeah, I think the attorney should be at that meeting, to tell you the truth, because I think that hearing people describe, and I expect they will, their community of interest is going to be very important. I mean, they can look at the record, but I think it would be important to have them at that meeting. And then I think the final meeting, the final map presentation, because there probably will be questions that we will want to consult. Like, as we get asked questions, we'll probably want to be consulting.
Well, when you think of the total number of input meetings that the commission is thinking of, it sounds like you're looking at a small subset of those for this for the lawyer to be present. Is that right?
Let's take a step back, and what is it that we want? Why do we want, I mean, why do we want the lawyer at the public regional meetings?
Well, if there is public testimony or any submissions that has some bearing on either a Section 5 county, so for example, if we're in Salinas or thereabouts, I think the attorney should be for that one, because that's right next, or in a Section 5 county. It's hard to predict, because I think that we're not necessarily going to be able to know at any particular hearing whether there's going to be a Section 2 discussion. Definitely at the statewide input hearings, where we're expecting to hear from certain groups and from the parties and various legislators. I think those definitely. So I don't know, and unless we're trying to say within the agenda, if we're looking at Section 2 questions, this is the meeting you go to, not the general ones, which we might want to consider that. Then we could say, well, those are the meetings that the VRA attorney really should go to, because that's where we're going to focus
But
on.
how do we know which ones those are going to be?
Well, let's say we're doing certain regions. We say that the regional meeting for Northern California is this. Let's say we have 3. The one that we're going to take specific testimony regarding Section 2 or Voting Rights Act issues at this one meeting. We can certainly accept it at others, but for purposes of scheduling when the VRA attorney really has to be at, unless we're saying all of them, and that's another option. But if we're going to say you're only going to do a subset, we can designate those meetings as specific to Voting Rights Act questions. Now, again, anybody can come into the meeting, if it's a more general one, and say, well, by the way, there's a big Latino population here, and I think you ought to be looking at this because there might be a Voting Rights Act violation. We'll have the transcript. We can convey the information. But if we're in fact trying to not have the attorney at every single one of them, we have some control over which ones we can specify.
I'm trying to think of when I've done this in a completely different context, and I'm not sure the attorneys went to all the meetings. It was more important for them to debrief with the people who did go.
Yeah.
Closely.
Yeah.
Very closely, for what they heard and like blow by blow, than to actually be there.
Yeah.
I think you're right. The state. My sense is, as you get closer to the presentation of the maps, and your time gets compressed, there's going to be a moment in which you're going to want to have a very, almost like a synchronicity between the line drawer and the map and the attorney that's very, almost real time. We may get into situations where I have no idea, where somebody says, well, what if the line was like this? Right? And you want to...
What if we said to them, we're interested in receiving a fixed price, but exclusive of attending input meetings, give us your daily rate for doing that, because we're just not sure how many they should.
That's right. But I would then maybe expand a little bit to say, and maybe it's in here and I was just late, but sort of an expectation that they will be reviewing documents on a daily. You know, that they will be reviewing documents at least on a, I don't know how you quantify it.
And these are input documents you're thinking of from community members and groups?
Yeah.
Okay, well, I think
And they're going to want to look at transcripts, and they're going to want to be, you know, they might even, who knows, it is possible, and I haven't even thought about this till now, that they may be talking to county attorneys or city attorneys in some jurisdictions. I mean, they may, you know, maybe spending time with other attorneys. So they're going to be. So I think they have to have they're going to do a heavy amount of document review. I think there's going to be a lot of and a lot of consultation, I think, with commissioners, more than they expect. Like, not just full commission. I really think it's a staff attorney. The closer it reads, like I think if you thought of it, like, what would I draft if I was drafting a staff attorney? Description, high level, very, very high level, but still, like, what that person would be doing if they were there 5 days a week. That it should read as much like that as possible.
Yeah, no, that's always been my vision of what the position ideally should look like. And again, I'm open to these other options simply because we need to keep those options open. But my feeling is the optimal position for the commission is to have a full-time staff attorney that's just there and covers as much as possible.
And if they're not at a meeting, somebody that is calls them on their cell phone and says, look, pull up the map. Look at this. And they pull up the map